Welcome to the Compliance 911 Show, a no-nonsense podcast discussing hot topics for today's busy compliance professional. It's everything you wanted to know about regulatory compliance, but we're afraid to ask. And now, here are your hosts, Dean Stockford of M&M Consulting and Len Suzio of GeoData Vision.
Dean, I'm really excited about today's topic and today's guest speaker. The topic is President Trump's Executive Order 14281, Restoring Equality of Opportunity and Meritocracy, which he issued on April 23rd of this year, 2025, which seeks to limit the use of disparate impact fair lending theory, legal theory, by federal agencies, and even state bank regulatory agencies and state AGs. And to discuss this topic with us, we have Lori Sommerfield of she's a partner in the firm Troutman Pepper Locke, and she's in the firm's Consumer Financial Practices Group. Lori's had more than 25 years of experience in federal government, in-house, and private settings. She works with clients in all aspects of regulatory compliance. I personally have worked with Lori in recent years as she defended clients that were threatened with redlining referrals. I can tell you that she was 100% successful in persuading regulators not to proceed. A year ago, we had Lori as a guest to discuss redlining and the Combating Redlining Initiative. We received such great feedback from the audience about that podcast. We said, why argue with success? So Dean and I have decided it would be great to have the superstar back for another podcast. So welcome to today's podcast, Lori Sommerfield. Lori, it's a pleasure to have you back to discuss a controversial, timely topic for all banks.
Oh, thank you so much, Len and Dean. It's a pleasure to be with you both again.
Great. Well, today we're going to talk about a very timely, very exciting, and very confusing topic. And we know that with your legal brain, it's all going to be clear to our audience when we're done. We're going to be talking about President Trump's Executive Order 14281, Restoring Equality of Opportunity and Meritocracy, on April 23rd, 2025, which seeks to limit the use of disparate impact fair lending legal theory, getting tongue-tied there, by the federal agencies and even state banking regulatory agencies and state attorney generals. Now, Lori, it's my understanding that there are three legal theories under which federal government agencies or plaintiffs may assert claims against lenders under the federal fair lending laws, which are the Equal Credit Opportunity Act, ECOA, and the Fair Housing Act. One is overt discrimination, two is disparate treatment, and three is disparate impact. Overt discrimination doesn't occur very often anymore, so our discussion today will focus on the other two legal theories, and primarily disparate impact, which is of great importance to lenders. We will divide our podcast into two segments because this is such an important and timely issue, and we want to examine it in depth, one of the leading legal minds in consumer compliance. So I have the honor of starting out with the first question, and then it'll be followed up. Dean and I will be alternating questions for you, Lori. We'll be interrogating you without mercy. So, because you've got the brain to handle it. So, as a threshold matter, can you define for the audience what disparate impact means and how it differs from disparate treatment legal theory?
Sure, Len. Evidence of disparate impact can be found when a lender applies a facially neutral policy, procedure, or practice uniformly to all credit applicants, but the policy or the practice has a disproportionately adverse impact on members of a protected class group. And a protected class group can be something like women, minorities, or seniors under the federal fair lending laws, and doing so without proper business justification. Evidence of disparate treatment, on the other hand, can be shown through circumstantial evidence that a lender intentionally treated similarly situated persons differently on a prohibited basis. It's a form of intentional discrimination, but the proof is based on circumstantial evidence. And I'd like to note that disparate impact is typically proven through fair lending statistical analyses, but disparate treatment is usually shown through comparative file reviews by examiners. However, disparate treatment can also be shown by statistical analysis, as you both well know.
Yeah, and we see that we see that regularly. I think in our data analysis that we do learn more regularly. But so how have the federal banking agencies in the Consumer Financial Protection Bureau used the disparate impact theory in examination, supervision, investigations, and enforcement matters over the years? And then I think the second part of my question, has use of disparate impact theory changed over the course of time?
Those are two good questions, Dean. So let me address them each in turn. But first, I think it's important to note that disparate impact is a judicially created doctrine, and it's been used opportunistically by the federal regulators over the past several decades, beginning in the early 1990s. And by federal regulators, I'm talking about the federal banking agencies, the CFPB, and the U.S. Department of Justice, or DOJ. How regulators use that theory has sometimes surprised the financial services industry because its usage often hasn't been completely consistent with federal court case holdings. The judicial traditional three-step burden shifting test goes something like this. First, the government or plaintiff first alleges that a policy, procedure, or practice causes disparate impact. Second, the burden then shifts to the defendant to prove that a business justification exists for that policy, procedure, or practice. Third, the burden then shifts back to the government or plaintiff to prove that a less discriminatory alternative existed and the defendant should have used that. But the three-step burden shifting test outlined in federal cases has been adjusted by some agencies in the way they apply it, including, for example, HUD in its disparate impact rule. So while the disparate impact doctrine has been used by federal regulators for many years, we saw a sharp increase in its use during the Obama administration. For example, DOJ launched a campaign to ramp up mortgage-related fair lending enforcement, using disparate impact as a primary tool to address disparities after the Great Recession of 2008. The CFPB also began actively using the disparate impact theory in 2013, as you'll recall, concerning the use of dealer markup by auto dealerships. Then during the Biden administration's Combating Redlining Initiative, which was led by DOJ, we saw federal regulators frequently seek to use statistical analysis alone, usually through peer analyses, to bring redlining claims under a disparate impact theory, without evidence of other factors that could indicate redlining practices had occurred. But on February 5th, 2025, we saw AG Bondi issue a memo that seemingly began to counteract that concept. The memo, which was entitled Eliminating Internal Discriminatory Practices, led to a conclusion that statistical disparities alone do not automatically constitute unlawful discrimination. So that was helpful. Now, with the issuance of Executive Order 14281, the industry is free, at least for now, from use of the disparate impact theory by regulators in examinations and supervision at the federal level. But it's evident that there likely is going to be very few investigations or enforcement actions during the current administration unless they involve some form of intentional discrimination. And by that, I mean either disparate treatment or overt discrimination used as legal theories. So, Dean, that's my long-winded answer to your two questions.
Well, thank you very much, Lori. I really appreciate that. And I have, and I know Len can attest to this as well. Looking at data analysis, it's amazing when you look at how it sometimes it's borne out that you have these anomalies just in the data alone, and how regulators use that anomaly to cite folks or write them up, I should say. So it's very interesting to say the least.
Yeah. Well, actually, if I could add in a comment here, Lori, too, before we proceed to the next question. But you and I've had the pleasure of working with you on several situations with mutual clients, and you, of course, do the legal side of things. And my company's been collaborating with you in terms of looking at the data itself. And one thing that troubles me is that this heavy reliance on statistical significance. I have found it's almost assumed by people that if you get a statistically significant result, that's infallible proof that there's some kind of discrimination going on. And my experience has been, as someone who understands statistical significance and statistical analysis, is that frequently there's factors behind the scenes that undermine the accuracy of this statistical significance factor. In fact, you don't know it, but one of the cases you and I were involved in a year ago or so, we've gotten actually looking at that more in terms of, is it like a case study? And what we found, Lori, was in that particular case, there were 45 lenders who were identified as peers for this particular bank. And when we applied the same statistical significance test to all 45 lenders, we found that 23 of them failed the test. So half of them basically didn't meet statistical significance requirements. And that basically tells you there's something wrong. There's some kind of assumption built into the model that distorts the results. So your ballywick, of course, is law, and mine is statistical analysis and data and that kind of a thing. But it's something we learned as we did that. So when you and I collaborate on future situations, that's something that an experience that my firm has had that I think will be even more effective working with banks who are threatened with something like this. And as you pointed out just a minute ago, it's not likely to happen in the next 3+ years during the Trump administration, but who knows who's going to be the next administration. And of course, all exams are retrospective. So that means whatever you're doing now may not be subject to scrutiny by the Trump administration, but it certainly will be subject to scrutiny in a subsequent administration. So I know you join me in saying this, that lenders can't let their guard down whatsoever, no matter what the current environment is.
Yeah, and I also think, Len, just to play on that before you get into the next question, but is context, because one of the things that we've seen is a lot of pushback from financial institutions in the data analysis as it relates to the peer comparison, which then results, because of the market data that comes out of that, results in that significant variance. And so, that to me, that's also another area that should be somewhat challenged, in that how do we define the comparisons in the peer groups, and what is the context? What's their asset size? How many branches do they have? Are they primarily in the mortgage business, or are they in a commercial? So, I mean, I think, we really have to put some context behind that, because the data itself just doesn't tell the whole story. So,
I completely agree with you, Dean. I mean, it seems that there's a fundamental disconnect between the regulator's definition of peers versus a financial institution's more in-depth understanding of whom its peers actually are.
Yeah.
Absolutely.
And sometimes, again, the peers can be not so much peers. Like, again, in that case we're talking about, we found out that a lot of the so-called peers were mortgage companies. And so the mortgage companies substantially impacted what was statistically significant. Once you remove them from the peer group, the bank's results were not statistically significant anymore. So we're going to work with you, I know, in future situations, Lori, but I know that one thing we've benefited from is learning as you go about this and how it's been applied by the government. And we could probably have another seminar just on that topic alone. Uh,
I agree.
I'm going to proceed ahead. And we are focused today on presidential executive order 14281. And I want to ask you what it requires. But before I ask you that, I want to ask you, more generally speaking, what exactly is a presidential executive order, and how does it fit in with law? How does it fit in with regulations? If you could address that question and then go into the specifics of 14281 for our audience.
Sure. Happy to briefly address that, Len. Well, as you know, United States presidents have quite a bit of discretion in terms of issuing executive orders to carry out their agenda. And an executive order is a declaration by the president which has the force and effect of law. And it's usually based on existing statutory powers, and it requires no further action by Congress. Executive orders typically remain in place only during the pendency of a presidency, but some can continue into perpetuity, depending on whether it offends the next president. And if so, he or she would probably move immediately to rescind that executive order. And we see that happen with the change of administrations virtually every time. There's a whole work stream in which the incoming president and his or her staff takes a look at all the prior executive orders to determine whether they're inconsistent with the incoming president's agenda. And then they take action based on that. So again, an executive order does have the force and effect of law. So if there are directives to Federal agencies or the Attorney General, they have to abide by it. So, Len, as you mentioned at the top of the podcast, this executive order is called Restoring Equality of Opportunity and Meritocracy, and it was issued on April 23rd by President Trump. And it really represents a sweeping rollback of the federal government's reliance on the use of the disparate impact legal theory of liability. Specifically, the order announces a new government-wide policy to, quote, eliminate the use of disparate impact liability in all contexts to the maximum degree possible, close quote. And that's at both the federal and state levels. I find the state level somewhat surprising, personally. It also broadly applies to all executive agencies, including the CFPB and the federal banking agencies, and it covers regulatory enforcement as well as employment, government contracts, and grants. And as I view the executive order, it contains 5 key directives to both federal agencies and the DOJ. First of all, federal agencies are required to deprioritize enforcement of any laws or regulations that would impose disparate impact liability. So that's one of the most important aspects of this executive order. Secondly, federal agencies are required to review and potentially repeal or revise regulations and guidance concerning disparate impact within 30 days following the effective date of the executive order. Third, federal agencies are required to review all pending proceedings based on disparate impact liability and then take action in those matters in a way that's consistent with the executive order within 45 days. By the way, the term pending proceedings seems to include pending investigations and enforcement actions, but it's not really clear whether examinations are within scope. Fourth, federal agencies have to, within 90 days, evaluate existing consent judgments and any permanent injunctions that rely on the disparate impact theory, and then take appropriate action that's consistent with the order. And finally, the Attorney General is required to determine whether federal law preempts state laws that would authorize disparate impact claims, and then determine if federal action should be taken against states. So that's sort of the surprise aspect of the executive order, in my opinion.
So we might learn something from those reports from the Attorney General regarding, the impact on state regulators. She's supposed to present something to the president regarding that. So our question at least might get a preliminary response from the Attorney General. I'm certain that'll be contested. For sure.
Yeah.
But
It seems like the executive order also has some pretty strict timeframes in there too. So when you look at actually when it was issued versus what's happening, it kind of begs the question, what is happening? So I guess my question would be, so what have we seen so far, if anything, in terms of tangible evidence that the federal banking agencies, as well as the CFPB, are beginning to eliminate the use of that disparate impact theory in examinations and supervision?
Well, Dean, we have seen some activity, but we haven't seen any reports issued that pursuant to some of these requirements that are arising out of the executive order. But we have seen the OCC remove references to disparate impact from the Fair Lending booklet of the Comptroller's Handbook. That happened on July 14th. And last week, the FDIC did the same thing. I suspect the Federal Reserve Board will be next in order to establish consistency among the federal banking agencies. And we haven't seen any amendments yet to the CFPB's examination manual, but the Bureau did state in its 2025 Supervision and Examination Priorities memo, which was issued, by the way, on April 16th, that it only plans to enforce fair lending to the extent of actual consumer harm and only where there's evidence of intentional discrimination. While removal of disparate impact liability from the OCC's and the FDIC's examination manuals might reduce compliance burden for banks those agencies supervise and lead to fewer supervisory issues and enforcement actions at the federal level, so far, there's been no indication that states plan to follow the federal government in shifting away from disparate impact reviews.
Okay, Lori. So what does Executive Order 14281 and federal agency action mean in terms of what financial institutions should expect for fair lending enforcement under the Trump administration?
Well, clearly, use of the disparate impact legal theory is off the table during the current administration for use by the federal regulators because of this executive order. And we're seeing the federal banking agencies fall into line by removing references to disparate impact from their supervision and examination manuals. So that means that Those agencies and the CFPB won't be using the disparate impact theory during examinations or to identify any supervisory issues with regard to financial institutions they supervise. So I think this executive order signals a new enforcement approach by the federal banking agencies and the Bureau in pivoting away from the previous heavy use of the disparate impact legal theory to the use of disparate treatment and overt discrimination legal theories instead. As an aside, although this executive order seeks to eliminate use of the disparate impact theory by states through the DOJ conducting federal preemption analyses of state fair lending laws, I don't think that could be easily done, and certainly not for all 50 states. Federal preemption analyses would be very time-consuming and resource-intensive for the DOJ, and I assume that AG Bondi has bigger fish to fry. But that's not to say the DOJ might not be selective in terms of conducting these federal preemption analyses for certain blue states. So that's my take on fair lending enforcement under the Trump administration.
And we'll close this session just by reiterating what we all agree on, and which is that banks can't let their guard down simply because what they do today will be subject to review 3 and 4 years from now. And who knows going to be in charge of the policy at that point in time. It'll definitely be a new administration, whether it's a Republican or Democrat. We're a long way from that election. We'll see what happens. So
that's
my advice. Yes. And my advice, and I'm certain yours is too, Lori, plan for the worst and hope for the best. Basically, continue tightly reviewing potential fair lending issues, particularly redlining analysis, under the assumption that sooner or later, what goes around comes around. We'll come right back full into this again with disparate impact. And my rule of thumb in life is if you're going to have a surprise, make it a good one. So again, plan for the worst and hope for the best. And with that goal,
more about risk mitigation in part 2 of our podcast, correct?
That's exactly right. So we'll keep the audience waiting for part 2 to come up.
Thanks for listening to the Compliance 911 Show. If you like the podcast, be sure to subscribe so you don't miss an episode. While you're at it, please give us a like and review to help others find the show. As always, links are in the show notes, and you can always find us online at compliance911show.com. Follow M&M Consulting and GeoData Vision on LinkedIn for all the latest news and information on compliance hot topics.